afternoon. It's 3:07. Calling the meeting to order. This is a special meeting of the Education Outreach and Training Committee of the Sunshine Ordinance Task Force, City and County of San Francisco. I'm David Pilpel, Chair. Victor Young is our Clerk Administrator. Mr. Young, if we could have a roll call, please.
Member David?
Present.
David present. Member Oka? Oka absent. Member Highland?
Present.
Highland present. Chair Pilpel?
Present.
Pilpel present. We have a quorum.
Thank you. I'm intending to take the agenda items in order. No comments. Without objection, we'll proceed. Can you call item 2, please?
Item number 2, file number 12013, hearing on the determination on the determined violation of the complaint filed by William Clark against Howard Lazar Arts Commission for allegedly not providing documents of expense charges to the Street Artist Program for fiscal year 2010-2011.
Great, thanks. So we've continued this item several times. Perhaps we can wrap it up today, maybe not, let's see. Mr. Clark, if you'd like to give us the latest status, we'd like to hear.
Yeah, hi guys. Basically, I have not received anything new, but while I've been waiting for this, I did some research regarding the tape recording of telephone conversations between within the department, and there's actually, I want to sort of throw this in the mix right now, because in the past, the departments have been claiming that if the city attorney spoke to the department over the telephone, that information was not available to the public. And I found Chapter 8 of the San Francisco Administrative Code, which I'm going to present you guys with some of this. This is Chapter 8 documents and stuff, and it relates to sound recordings. And I would just like to bring to your attention that it states that a record is defined in this chapter shall mean any paper, book, photograph, film, sound recording, map, drawing, or other document. Excuse me, you could give this to one of these to each one of them. That'd be great. Okay. That sound recordings, records include sound recordings, and the responsibility in Section 8.2
Did you get one?
for the preservation and filing of records is the head of every department is responsible for the preservation and filing of papers, films, or other records. And in Section 8.31, which is the copy that I gave you there, it states that the word sound recordings as used in this section means the routine daily taping and recording of telephone communications to and from a department of the City and County of San Francisco, and all radio communications relating to the operations of that department. And Section B relates to the Muni Railway, the police department, and the fire department. And Section C states that any department not mentioned in Section 8.31B shall retain sound recordings relating to its operations for at least 100 days. And the reason why I'm bringing this up is that I believe that the conversations between the city attorney and the department head at the Arts Commission, those recordings, according to this, should be those telephone conversations should be recorded and held for at least 100 days, and that in the past, part of the problems we were having is that the city attorney was saying, hey, we're talking about sunshine, but some of these conversations were in phone calls, conversations, and we can't release this public information. So what I'm trying to do is that I'd like to find out if when the city attorney and the art commission talk over the phone and the city attorney gives city attorney advice to that department, whether those phone conversations are recorded, and if so, whether or not they should be held for 100 days and made available to the public, and therefore any conversations between the city attorney's office and the department relating to sunshine cases, although that information, those conversations should be recorded, because in the past, like we said, there's this catch-all phrase that, oh, we don't have any records about showing this, but these were all the departments are doing. These were conversations that we had, and we don't have any records of these conversations. And what I'm saying is, at this point in time, I would like to include in our little thing that we're dealing with here, the fact that if the city attorney is giving advice to the Arts Commission on any issue, at least regarding sunshine, and that information is being done over the phone, that those conversations should be recorded, a log kept, so that the public can be aware of what the discussions were. And if we want to have access to those recordings, we can get them within 100 days.
So let's pause your time for a second. Let's deal with this for a moment, and then we'll come back, because I want to hear what else there is. A couple of housekeeping things. Do you have another 2 copies of this? Can we get one for Victor for the file?
I brought 3 copies.
Okay,
here.
then we'll get one to Victor, and you just got the one from Member Highland. And in fact, Victor, can you share one with Mr. Lazar so that he can see it? This is a new twist. I'm just going to... I just want to make it go away. Okay. Okay, so let's see. And in terms of our packet material, we sent both of you a notice. Did either one of you submit anything new on this particular case?
I don't think so. I did, and I don't.
Mr. Lazar? I don't think so. Okay. The log that was in the packet was the log that we saw at a previous meeting. You've seen that.
Right.
We'll talk about that in a little
bit.
Okay.
Right.
So as to the sound recordings, we paused your time. You're going to get that back. If I can deal with that straight away, Mr. Lazar, if you can approach, and you'll certainly have your time on stuff. I just want to deal with this issue. As to sound recordings, based on the definition here, are you aware of routine daily taping and recording of telephone communications between your department and the city attorney, or for that matter, any other department?
Not aware of that at all.
Okay.
Yeah.
So to the extent that this code section applies, you don't believe that it applies to your telephone communications, because you nor anyone that you know of makes routine daily tapings or recordings of those telephone communications?
I've never done it in my dealings over the phone with the city attorney. I'm not aware of anyone at the Art Commission doing it.
Okay.
And as I mentioned in that previous hearing with you, it's like the city attorney has advised, have really dug in on this issue. And they said, basically that disclosure of communications between the Arts Commission and the city attorney's office would chill the Arts Commission's ability to discuss candidly issues
Understood.
With legal advice.
Been through all of that stuff. I just wanted
to remind you of that.
That's very good. I appreciate that. But just to confirm that there are no routine daily taping or recordings of telephone
I'm not aware of anyone else at the commission doing that.
Okay, so whenever any of us or any member of the public calls you, you're not making tape recordings of that. Okay, I just wanted to know that. That's very good. Thank you. Okay, thank you. We'll come back to you. So it appears that that under this definition of sound recordings, and I appreciate bringing this twist, it's fun and interesting, that they don't have such routine daily taping and recordings. As I understand this section, which I am familiar with, it is largely related to radio communications at Muni Police and Fire, for which there are retention periods and legal and other operational reasons.
That's true that it includes that, but it's not limited to radio communications.
It's not. But if they don't make routine daily recordings of their communications, then it wouldn't fall.
But what I'm saying is that now we have half of the equation here. The other half is the city attorney's office. Now, how do I know that the city attorney's office isn't recording these conversations? And doesn't this ordinance sort of imply that if the city attorney is giving legal advice to a department, that if it's over the phone, that advice should be recorded?
I'm sorry, I don't read it that way. We don't know what the city attorney's procedures are. Your complaint was against the Arts Commission, not the city attorney. You could pursue that.
Right, I understand
okay.
it, but in section 8.3.1, down at the bottom there, it says, if I can borrow your copy. The only point is, at this point, is it says any department not mentioned in 8.3.1b, which is the Muni Railroad, the fire department, and the police department. It says shall retain sound recording. Shall is a mandatory term.
But you need to read that with subsection A above that defines sound recordings.
I understand that, but the subsection A is just a definition of the word sound recording.
Right. So,
and this other subsection says that whatever the definition of it is, that this is a mandatory term that mandates them to do that.
But I read that to mean only if they have made such sound recordings. If they have not made the sound recordings as defined, then they're not required to retain sound recordings that they never made in the first place. It doesn't mandate that they make them.
You're interpreting that. I'm interpreting that to mean the routine daily. It says the routine daily taping means it's a routine act to tape daily recordings of telephone communications to and from a department.
Right. Where they do so, it does not mandate that they make routine
well, that's
daily
where
tapings.
You and I disagree.
Okay.
I mean, I think that this mandates that if a city attorney is calling a department head and giving a legal advice, and that department head's going to rely on that legal advice, that, like it says there, for the protection of the city and county for legal services, that those recordings those things should be recorded.
I understand. I'm just providing my feedback on that.
All I'm saying to you is that I would like to suggest to this, and since this is we're referring to the public, we're referring to specifically the sunshine discussions with the city attorney per se, which is all public information. That the only way we can get that public information is if those conversations are recorded, because the public's entitled to know what they're talking about, and therefore I would like to suggest that in the future, that any time the city attorney is talking to a department about sunshine-related things, whether it's the Arts Commission or some other department, that they record those telephone conversations and make the public aware that those conversations are available for the time periods that are stated in this code section. And so I'd like to add that to the mix. I know my time isn't running.
I think people heard it, and we'll see where the discussion goes. So,
because other than that, you just were told, and I was just told, that the city attorney isn't going to give us any more information.
no, I'm not sure that's what we heard. I think what we heard is that the department doesn't make routine daily taping and recordings of their telephone conversations, and further that the city attorney has advised that the disclosure of attorney-client communications would chill the candid conversation.
We're not talking about attorney-client privilege here. We're talking about conversations that occurred relating to sunshine specifically, and there is no attorney-client privilege relating to that. So what we're saying is, I've just been told by Mr. Lazar, even though he'll get his time to stand up here, that the city attorney has said he's not going to give me any more information, and that means I'm not going to get the information that this whole complaint started from.
Okay, well, I wouldn't necessarily reach that. So one thing at a time here. I think we've heard enough on the sound recordings issue. We'll open it up for further discussion in a bit. You still have some time. If you could tell us, however you choose to spend the time, but in particular on your original 8 points and where we are with them. That's what I'm interested in.
Well, as far as I'm concerned, the one point that's the most relevant point, which is to give us a brief description of what took place during those conferences, and to do that the city attorney is refusing to give any more language than what was given on the first log, which was just that it was Sunshine Brown Act related conferences. And the whole purpose of this was to get a little bit brief description of what those conversations were about.
Okay. Thank you, and we will hear back from you in a bit. Any other questions right this moment or discussion? Then let's hear from Mr. Lazar. Yes, very good. Okay. We'll have some follow-up in a bit. Mr. Lazar, you've got 5 minutes to tell us where we are on these issues.
I don't know where to add. I submitted to you the log. At a previous meeting, you had asked, for example, that we change the name of complainant to requester, and we did that. We built in a column that says time spent with city attorney, and that was it. Because again, it's our city attorney feels that we should not have to build in a column that says what the results of the advice were, or what the advice was about. So I don't know what else to add here. It seems like we're at an impasse here.
Okay. Let's see. It looks like we've got a copy of the updated log in the next case. The log that we have here was the older version. Is that?
Perhaps. The
Okay.
one I sent you most recently was attached to a letter of November 20th.
Or 21st?
It says November 20th
Oh.
regarding complaint number 12013. Dear Mr. Pilpel, with regard to your committee's November 26th, 2013 hearing, we're pleased to inform you. Did you
Okay,
have
hold
that?
on. I'm not seeing that.
It was an attachment to...
I believe you. Hold on a second. Victor, do you have the 12013 file?
This is...
Mr. Lazar, one second. Members, do you see the...
Well, I'm looking.
Yeah, let's look and see if we have that. We're all looking.
Okay.
If someone has the binder out there, if they could also look and see where this is. I believe you. We're just trying to find it.
Yeah, it was sent as an attachment
I believe you. Hold on. We're on it.
to Mr. Young
Okay. One
on
second.
November 21st. Okay.
We're looking. There's a lot of paper here. We're on
Yeah.
it. One second.
And it's a very simple letter. It's just 2 paragraphs and then the attached
hold on.
log.
We won't take this from your time. We're just working through this. All right. I'm not seeing it, so...
The heading is, the email says FW: Sunshine Ordinance Task Force Meeting, November 26 at 3.
Okay.
And it was responding to the notice that Mr. Young sent to us
Okay.
on November 15th.
All right. I'm seeing the November 21st letter, email, and attachment relative to the following case, but I'm not seeing the November 20th communication.
Well,
So-
November 20th is the letter itself.
Right, I understand.
Yeah.
I'm not seeing it, so maybe Mr. Young, and it was sent to SOTF or to...
It was sent to Young Victor and
Okay.
SOTF.
All right. So...
And it was, as I say, it was in response to Mr.
Yep,
Young's...
I got it.
email.
The original. Okay. So, one second. So, Victor, if we can just check somehow after the meeting on your email if this didn't work its way into the file.
I will ensure that it makes it into the file.
Got it. Okay, thanks. So could you then just summarize the two paragraphs? If there's, that would be great.
Basically that.
Can you put it on the monitor?
Oh, yeah, if you have do you have a printout of it?
Yeah, it's right here.
You want to throw it up on the monitor? That would be great.
Sure.
Thank you.
Well, I'll get to this part here.
It's actually the email, if you could put the email up there,
Yeah,
that would be cool.
okay. Okay, so here's the email.
Yep.
Please forward to Mr. David Pilpel, Chairman, and members of the Task Force's Education Outreach and Training Committee.
Sounds good.
The attached letter.
Can we go to the letter?
And then we go to the letter, which was...
Yep. Can you put it up a little bit?
Yeah, sorry.
No, no, that's good.
Okay, there it is. There's the...
Okay, give us a second.
Oh, you're getting it on your screen.
Yep, yep,
Great.
yeah.
It's the space age.
Everyone, you can read it? Everyone's good with this? Okay. Okay, and then the log is the attachment, and as I said, I think we've got the log in the following document, and you made some changes to it, which include, can you put it down a little bit?
Yeah, there we
Good,
go.
okay.
So
Time spent with city attorney, that was the new column added.
there's a new column, and
Very
also
good.
we changed, instead of name of complainant...
Yep, requester, got it.
Requester.
Okay, and it's got the archive file, all that fun stuff. Okay.
Yes.
Great. So I think that reflects the ongoing discussion we've had. I'm sorry, we've walked into your time.
No, I don't...
Tell us whatever else you'd like to tell us.
I don't have anything else to add.
Okay.
So, yeah.
Okay. Great, thank you. Well, yes, we asked for some other things, but this is along those lines. Sorry, we're being slightly less formal than usual because it's just we know who all's here and all that. Ms. Datesh, did you want to speak in support of the complainants, or did you want to wait for public comment?
There's general
Please come to the
comment
microphone.
on this issue, right?
There will be, yes.
At the end, or there's on in support of the complainant.
Correct.
Oh, wait.
That's for you, by the way. And Mr. Other Clark, did you want to add anything at this time?
Robert Clark. Yeah, what he's provided does not give us the information that this whole complaint started on. We wanted some information on what was being discussed relating to Sunshine Ordinance requests between the Art Commission and the city attorney. Now, all we're saying is all the city attorney is providing us is a statement that we've talked about sunshine requests, we've talked about Brown Acts. We want something more specific. This isn't about a chilling of the attorney-client privilege. Anything related to public records and public information requests is public information. The city attorney is required to release that information. Now, in our particular case, we're also paying for both of them to sit down and talk about it. It's not the city's money that's paying for it, it's the street art's money that's paying for it. So in effect, we have a situation where I'm paying Mr. Lazar to talk to the city attorney, and I'm paying the city attorney to talk to Mr. Lazar about questions that I, as a street artist, have, and then I'm being told that, well, we're not going to give you any of this information beyond the fact that we discussed public document requests. And so therefore, what we're saying is that until the city attorney and the Art Commission agrees to provide something more than just a blanket statement like we talked about sunshine requests, that we're not satisfied with them fulfilling what our complaint was dealing with. We have the right This is public information. We have the right to know. Generally, we're not asking for detailed information between a client and an attorney. We're asking for a general subject matter of what the discussion was about, and we're asking for a general conclusion as to what city attorney advice, if any, the city attorney is giving to the Art Commission. If we can't get that information, then we've just wasted everybody's time, and this whole thing has been a farce committed by the Art Commission and the city attorney to stonewall this whole thing. So all I'm basically saying is that we need that information. Everything else is fine, but everything else is minimal. I mean, I don't care if somebody's called a respondent or a complainant. That's not asking them to do anything. What they're refusing to do is to state in the log what the discussion in regards to public information requests dealt with, whether it's the name of the person and what the question was and what the city attorney suggests how it should be handled. That's all public information. We have a right to know it. So until the city attorney and the Art Commission are willing to at least list a subject matter that was being discussed beyond the mere fact that they discussed a Sunshine Ordinance request or a public information or a Brown Act request, this generic statement, it's meaningless to us. And then I just want to throw in one last thing, since I have a couple of seconds left, is I think it's important for us at this point, if we're going to go forward, I think it is important for us to tell the city attorney and the Art Commission that if they are having a phone discussion about Sunshine Ordinance requests, that they should record that phone discussion, because it is public information. Otherwise, what we've been getting on these lists is that, well, we had a phone call, and we know nothing about what that phone call was about. We can't even verify whether or not it really related to the issue of Sunshine requests, or whether they're just skyrocketing our bill to cost us more money.
I think we got that. If you can do me a favor as we're looking at the log, and you have a copy of the most recent version of the log here somewhere, somebody?
Right here.
No, that's not the one that is shared.
The November 21st dated log is attached to a two-page letter, also dated November 21st, relative to the next item. So it should be in the binder in the packet there, or if Mr. Lazar has a copy to share. What I would ask you to do, Mr. Clerk, if you can pick one or two items on the log that you might be concerned about, and tell us what additional information you might be looking for that would address your concerns, either now or in a couple minutes.
I think I can do it.
Okay.
We can get to this fast, Well, under the descriptions, referring to, there should be, anytime there's a public...
I understood the general, but if you can pick like a specific line, and Mr. Lazar is listening, and then maybe we can talk about that for a second.
Well, let's go through. We have date, no problem. Received by, no problem. Program, no problem. Description, let's hold that for a second. Name of requester, no problem. Requester contact info, no problem. Due date, no problem. Date completed, no problem. Estimated time staff.
Hold on, and one second. And to Mr. Lazar, some of these fields you're going to try to clean up because they're in different formats. So, I'm sorry. On date completed, some of them have 11-12, which is one format. Then the line above on line 16, for example, is 12.10.12, and I think another one here had a slash. So
Consistent, you mean, is that it?
Yeah.
Both?
yeah, so different people are using different date
Yeah,
formats.
exactly. This
Okay.
is a log that's used by the whole Art Commission.
Okay,
Yeah.
but if you could perhaps, it might help,
Make it
that's all.
consistent.
Yeah, okay. sorry, keep going. We were at,
Okay, Sunshine Task Force number, if applicable, certainly that's fine, no problem. Time spent with city attorney, no time correspondence. But there's nothing in here that says specifically what the subject matter of each specific.
we'll go to the description line. Is that insufficient, or can you point to a specific line item here where you might be looking for a more descriptive description?
Well, there's like response to SOTF complaint, immediate disclosure, CD audio, immediate disclosure, street artist program budget, but it doesn't state. It states the subject of some of the requests from that point, but it doesn't state what the city
Okay.
attorney's response was.
Fine, so let's go to page 2 for a moment, where we've got time spent with city attorney, which I think was added for fiscal 13-14. Okay? So I see 3 line items there, starting with line number
Right,
3
I
under
see it,
13-14. Howard Lazar, additional employment, 15 minutes, Vera.
Right, and
Okay.
there's one there, 3 hours, the third one there, 3
Right.
hours. Now, 3 hours sitting with the city attorney to discuss something related to Sunshine, if that's involved
Okay,
in
well,
Sunshine.
then let's look at that. It says IDR, or immediate
Right.
disclosure request, time limit, Board of Appeal decision, repeat quest, or maybe repeated question, I don't know.
That's-
What, is that sufficient? Is that not
Not to
sufficient?
me, it isn't. Doesn't
Okay.
tell me what. For one, it doesn't. I have no clue of what that's really about, and two, it doesn't tell me what the final, what the conversation between what the city attorney's advice was or
Okay.
conclusion was.
So let's focus on that, because that seems to have most of the elements. If you can step back for 1 second, Mr. Lazar. Sorry to put you on the spot, but hey, that's what we do here.
So which one was that?
Howard Lazar. HL is Howard Lazar? Yes?
Yes.
Okay. Who is that guy? Never mind. Line 10 under fiscal 13-14. So this is page 2 of the log.
Page, yeah, I'm on, page 2, okay.
Show the law. It's the one that has, it's the one that has that, we're talking about time spent with city attorney, the one that says 3 hours. That is the.
I see it.
That's the line
Krell
we're
and
discussing.
Vera.
Yeah.
Right, so that's what I was told.
I'm there. So I have a question. When you say that is what you were told, I'm just trying, where I'm,
I see it here. That's regarding the immediate disclosure request, time limit on Board of Appeals decision, repeat request, and that was by Paula Datish.
right?
And I was told by my supervisor, who is Rebecca Krell, that she was talking to Aideen Vera about this, and that's 3 hours. So that's time spent with the city attorney.
I didn't file an immediate disclosure request.
We will hear from you, not right this moment, but in a bit. Okay, so
Yeah.
is there any other information that could be captured here, or
No, because
not?
the bone of contention is what you know. So all I could say is that if you want to know what the topic of discussion was with the city attorney, it's under the description column.
Okay.
But there's no conclusion, which Mr. Clark would like to see. There's no conclusion there, and that's the bone of contention.
So, may I? Yeah. Okay, so let me ask you this. So, if the conclusion, after discussing with the city attorney, right, if the city attorney offers you advice that has nothing to do with Sunshine and nothing to do with the Brown Act, just advice. Clearly, that is attorney-client privilege. When the city attorney offers you advice on the Brown Act or on the Sunshine Act, that does not fall under attorney-client privilege. Right? That is where we're all in agreement on that, are we not?
Are you?
I'm asking.
Because I can hear the city attorney now disagreeing with that.
We're not the city attorney.
Right, this is what
My belief is in this room, there is general consensus that advice relative to compliance with the Brown Act or the Sunshine Ordinance is not protected by attorney-client privilege and is generally made available on request. It's not like we post it on the walls everywhere in town, but if someone asks what was the advice, that's, the ordinance says that advice shall be disclosed. I think there's general agreement about that.
That's my understanding on something.
I hear heads nodding. Okay,
Right.
yeah.
So my question is that where I guess I'm having a hard time wrapping my head around is how do we know? So and I apologize, Mr. Say the Clark brothers. I know it's not both of you, but I'm just going to say the Clark brothers are saying that you received information from the city attorney regarding Sunshine or the Brown Act. Okay. If so, they are saying that what information you received should be disclosed. Where I kind of start chasing my own tail is that if you were talking to the city attorney and it was just, no, you don't have to disclose that. Like you weren't discussing specifically the Brown Act or getting advice. Like how it's this. I don't know how to differentiate between without someone saying, "Oh, we were talking about the Brown Act, and this is what we talked about during the Brown Act." Right. This is where I'm having a hard time.
Okay.
I'm chasing my tail a little bit on this.
So let me try to rephrase that a little bit, but how do you make a distinction or draw a line between whether a street artist is conducting their business consistent with the program or the certificate and is disciplinary action or some other thing warranted to is this an immediate disclosure request, and do we have records that we need to disclose? When you get into conversations that include both of those topics, do you say, well, look, this is the Sunshine part and this is the program part that's not specifically Sunshine? How do you make that distinction? Is that sort of what you're asking?
Actually, I don't know if there is a distinction.
Well, I think there is.
Do you? Because,
Yes.
I mean, I can see it, for example, if it's about employee, let's say, there's certain confidentiality there, but we've had to turn over records about employees with confidential things redacted from them. Okay, so
That would be a public record request.
Yeah, so that was sunshineable. So, and if we're talking about disciplinary case of a street artist, if we're talking about the budget, if we're talking about anything dealing with street arts ordinance, I mean, isn't it all sunshineable?
Well,
with the exceptions of certain confidential details that would need to be redacted.
it may be, but I think if
So I think that where I understand what you're saying, but I think where the line is right. And this is my opinion, that the city attorney telling you which information is redactable and which is not, that is public information. Right, just saying that in general, right, addresses are, whatever the advice is in general about how to conform with Sunshine, that is public information. The specifics of an individual case, right, is not. That would be that's how I would differentiate it. Is that I don't know how other members feel about that.
Yeah, hop in.
I have a question. So the original determination that we had at full committee was that they were in violation of these records. Their request is very specific about communications resulting in $20,000 worth of charges. Now, I used to work in a law firm. You used to have to bill every 6 minutes, and you have to put it to what contract you're working on. Perhaps they should be addressing this to the city attorney's office. That's one avenue, because they should be keeping records of that detail on this and other matters. However, what records is the Arts Commission required to keep on that? Maybe none. Maybe this is we're chasing the wrong tail here.
Use the mic.
Yeah, I'm talking to you guys.
No, I agree.
So I'm just trying to see if we're on the same page with that. So
Yeah.
having said that, I still find the Arts Commission in violation, as we originally did. Nothing has changed. You know, slight changes to titles of blogs is nice, but not anywhere near the original order of determination that we issued. Therefore, can the Arts Commission actually provide this information? Do they have it? Or does this information really reside at the root source, which is the city's attorney's office? And we're all wasting our time here if that really is the case. Does this have to be rerouted? Do we have to write a letter to them? Do they need to release what they can, redact away as much as they want, but give the Clark, Mr. Clark, you know, the satisfaction of seeing the $20,000 worth of work done in relation to the art, you know, the Street Arts Commission?
Well,
I mean, I'm just trying to like keep us focused.
yeah, no, you raised some good questions. We can continue to, and we will talk a little bit more about the log and where we go with that. I'm just thinking out loud, maybe either on this complaint or as a separate matter, just in general, on how records are kept or advice given between the Arts Commission and the city attorney. I don't know if she'd appear, but maybe we should request Ms. Vera to come, because we all seem to be talking about this without Ms. Vera, for example, being present, and maybe she would, and maybe we could, you know, get to the root of this one way or the other. I don't know if that's useful or productive. I'm just thinking.
I have
Go
a
ahead.
question for Mr. Clark.
I just
Mr.
want to
Clark,
remind you.
Hold
that
on one second.
Just to follow up on what I was thinking out loud here, and I have to look back. Did you include the city attorney in any of your...
I filed a complaint against the city attorney specifically for this information, and this task force dismissed the complaint, saying that they didn't have to give me any more information because they were claiming they didn't have any more records. So I did go in that direction first, and that's why I came back through this method to see if I could get, at least when the complaint, since the Arts Commission is the one initiating the discussion with the city attorney.
They're the client.
That at least on the public records issues, that right from the get-go, we'd be able to keep some brief
I agree.
information
I agree.
and result of what those discussions were. But I did try to do that.
Thank you. That's important because, you know, if
And I wouldn't mind doing it again.
well, you might have to, because, you know, if it's a very elegant dodge if the Arts Commission isn't required to keep these types of records and the city attorney doesn't have to provide that record, if it exists, which it must, you know, for just, you know, good billing practices at any law firm.
Well,
I mean, that's...
We have been down part of this road. Let's note that in the packet, we've got the billing detail, and I still have an outstanding issue of whether there's another field that's not being displayed here. I'd heard that there might be. I heard that there wasn't. I'm not clear on whether there's a description field that we're not seeing here. I would love someday to get an answer to that question. I would like to put this to bed today if we can, but we don't have to. If in the packet, you're all familiar with the city attorney report,
The city attorney log.
the time spent.
Yeah, this right.
Okay, which is different from the other log that we were talking about.
Right.
This is their time spent report.
Right, but if
so. Hold on a second. So, as I said, I'm willing to dispose of it today. I'm willing to continue it. We can, you know, try to invite Ms. Vera or somebody else, whether they're willing to appear or not. I don't know. I suspect Mr. Lazar is willing to carry that request. You know, I would like to get us as much as we can that is reasonable and disclosable. I don't want to burden the department to a ridiculous extent so that, you know, we have to hire an army of people just to track the requests. I think that it gets disproportionate, but I want to come up with something that's meaningful here. I think we've gone some distance with it. I recognize that it's not everything that you want, but I'm trying to see if we've got something that's good enough and workable. I don't know if we're there yet.
Well, from my standpoint, from my end, we're not there yet because because most of the stuff that we already had as a result of between the log and the city attorney's thing. And like I said, I want to try to keep this simple too. And all it is like when I go, because we went through this, and when I go through these things and I see, 2 hours and 2.75 hours spent on a California public records request, and I go to the city attorney's office like the gentleman just asked me, and they said, well, we don't have any more information, we can't give it to you. And then I go to the Arts Commission and try to say, well, here's a situation where 2.75 hours was spent with the city attorney. That's an awful lot of time to sit down and to talk about redactions and just simple things that dealing with the sunshine. And so let me just try and sum it up.
All I want to say is, as we go forward, if people can think of more solutions than problems, I'm interested in what specifically we can do or what we can ask be done. So think of ways to solve this.
All I'm asking to be done is the log looks great for what it has, but the one thing it's lacking is the end result of the conference, the conclusion that was met between the department and the city attorney.
And I've heard that, so let's
if
get in on
it
that.
literally said, we discussed redacting, would that be enough?
If it said we discussed redacting on this specific case, that would be at least something.
So I guess one of my I kind of feel like we're getting
But I get your point.
I'm wondering to what
extent.
If they say we
How
discussed,
much is enough?
Right, if we discussed Brown, the Sunshine Ordinance 6.7 that's what we discussed.
Right, and if it said if we discussed whether this was an attorney-client privilege in this case and what needs to be redacted, and we determined that this, and this was the conclusions, but to do it in a way that.
Because clearly in the city attorney's log, it is saying that they discussed the Brown Act or the.
I've got a bright idea.
Yeah.
Mr. Lazar, if you can join us on this. Anytime not just you, but anytime the Arts Commission staff is spending in discussion with the city attorney, could you make it a practice to say at the end of that call, meeting, discussion, that you're going to come up with a brief description of what was discussed, whether it's discussed redaction of blah or discussed applicability of 67.16 to instant case or reviewed personnel file for redaction, or just some few word description?
I don't have a problem with that. Okay. I'm
Is that something?
Football here.
Yeah, no.
Right?
That's what we're trying to do.
Okay,
Could we make that a practice when time is billed to the city attorney?
Doing that.
Okay. And adding that to the log?
But
Okay.
I would like to see, if I may, a letter from you folks to the city attorney stating, you, sir, what you were talking about, and that is your interpretation, your consensus, and send it to them. I'm tired of this. I know you're tired of this. I'll do whatever they want me to do. Okay. I have made it a practice to follow the city attorney for 41 years.
Sure.
Okay. So, but clearly we're in a whole new realm now. We didn't have sunshine 41 years ago. We had Brown Act, but and perhaps maybe there is some kind of a conference with Aideen Vera or another attorney on this that could facilitate this whole thing. But so I just want you to leave you with that I'm cooperative to.
Okay, we get that. I'm not disagreeing.
Right.
Okay, so think about that at the end of any conference where there's time billed, where you're putting something in that time spent column, where you could come up with a few words that gives a brief general description of.
Better yet, add a column next to it.
Yeah, right. Either in that column or in another column, whatever. We'll end up with 29,000 columns, but whatever, that's fine.
I'm willing to do it.
Okay.
But I want to go ahead from the city attorney.
That's fine, and we're happy to. Can you make a note and draft a little thingy for me on that?
Noted.
Okay. Well, somebody needs to help me write that. I can't do everything here.
Yeah, absolutely.
Okay. Mr. Clark, would that go some substantial distance to...
I would be willing to
Before you ask that,
continue.
Hold on, 1 second.
I want to add one other thing. I think in that log, and again, we'll include this in the letter of the city's attorney, there's a couple of instances where you've referenced SOTF cases. That's great. That shows time and material spent towards certain things. I'd love to see that in the city attorney's records. No indication whatsoever. I mean, it's got, well, that's not true, unless they're all file 000.
But that's up to them and how they build. So we'll have to figure out how to talk to them about that.
Yeah, but at least for the street, for the Arts Commission, that, that level of detail would be great, rather than just general statements about general topics.
Yeah, no, and in some cases, it's in the description column that refers to task force case numbers. In other instances, it's in the other task force column. But whatever, there's some there. So back to the question, Mr. Clark.
Well, I'm just saying that since we're getting closer to solving this situation, is I would be willing to continue this for a month, have you send a letter over to the city attorney, basically, expressing your opinions, and perhaps suggest that Aideen Vera attend the next meeting so that we can separate these two issues, as between the attorney-client privilege and the sunshine public information. We can at least get those, so we're not being told that this is all attorney-client privilege. And I know Mr. Lazar is standing here saying he's willing to do it, and I believe that he is, but he's being told by the city attorney, don't release it. We're telling you we're not going to do this. So I think it is important maybe to bring somebody from the city attorneys to deal with this separate issue, and let's see what they say at the next meeting, and then we can take it further, because we're almost there.
All right, we appreciate your flexibility. And, I think it's two streams here. One is asking Mr. Lazar to provide more details in his log and getting the sign off the city attorney. And secondly, I still kind of like to see the city attorney give us what they have, redacted as much as they want, that's in addition to this, because I'm sure there's more complete records than that. So that's another topic, and that's something we can discuss with them and tell them that, for future, expect this, because, that's the road we're going down.
I have a suggestion. So, first of all, I think that Mr. Lazar has been has really gone out of his way to try to be compliant with what, trying to work with the Clarks and with us. And so I feel like, everyone's being a good actor here. I'm wondering that if it might be worthwhile to refer this back to the full board, to the full commission, for two reasons. One, our city attorney will be here, where we can ask our city attorney directly, because I feel like I have heard...
Point of order, we don't have a city attorney. They just advise us. But anyway.
Wait, but I'm saying that, but DCA 3, I know he's not our DCA anymore, but I...
Really?
Yeah.
Right, but I clearly remember DCA 3 stating that any advice from the city attorney that goes towards the Brown Act or towards the Sunshine Ordinance is not covered by attorney-client privilege. And it sounds to me like Mr. Lazar is getting different information from the city attorney that he speaks with. And so
I'm not sure. I don't know if that's true.
Okay. That's what it sounded like to me. I could be wrong.
I think it would be interesting, actually, to maybe put this before a full committee and still have Vera here with our city attorney.
Right.
Have both of them here.
That's my
That might be interesting.
suggestion.
But that's almost another...
I'm not... I guess I'm disinclined to bring it back before the full task force unless we're going to recommend referral or some other major action. Having more people here to talk about this, if we could get Ms. Lee, if that would be helpful, I'm not averse to requesting that and trying to make that happen. Having the full task force hear it for purpose of hearing it, I'm not sure where that goes. I'd really just like to solve this. So if we have a
Can
way...
Ms. Lee come to a education? That's the only
It requires, hoops and requests and whatnot, but it's potentially doable. One sec, we'll hear...
Second, it's been an hour. Can I just do this public comment?
We're not a public comment just yet.
I'm sorry, and then we have your case to hear, Ms. Ditesh. I tend to think that
Okay?
Okay. I tend to think that it would, I tend to think that this would be most productive if we could get Ms. Vera, if she'd be willing to come. I don't know because, they've got hoops and issues over there. I guess I agree with the evolving thought that we're getting somewhere.
Could I make a suggestion to you?
Go ahead.
Is it possible for you as a body to ask for a city attorney written opinion on whether or not the city attorney believes that all those requests are public, or attorney-client privilege? Because I do feel like Howard, Mr. Lazar is saying that the city attorney is saying they're not going to release any more descriptive information based on attorney-client. But can you, as a body, request a written city attorney opinion?
We can. I think that they would largely direct us to the Good Government Guide, which says in relevant part that advice on these matters is public, and that's true.
Right,
Hold on.
right.
But, creation and maintenance of a log and additional detail is not something that departments are required to do, and they may do on their own.
But that's not the issue that I'm asking for the written opinion on. What I'm saying is that any city department has the authority to ask the city attorney for a written opinion on a legal matter. And I'm just questioning why can't you folks, when you have a disagreement, when your attorney may disagree with their attorney, is to get a written city attorney opinion. That way,
We could, but I'm not sure that there really is a disagreement, and I think the advice in the Good Government Guide is fairly clear and consistent.
I'm just suggesting that if you decide that you feel
Do we have the Good Government Guide in the binder? Can somebody maybe find the relevant section there? Because I know I've read it.
While he's looking, I think we're on the right track. Both parties are flexible. If we can put out a letter and a request both to our city attorney and to their city attorney advising the Arts Commission to be at the next scheduled meeting, and in the letter we can state what we're going to talk about. We should,
Okay.
and then hopefully we can resolve this. I think that's, and then failing that,
Then we could escalate the matter. Yes.
escalate it, and then
I agree with that.
Okay.
I actually feel like that
Talk
the
to him on
resolution of this, a resolution of this case is going to be incredibly helpful in the guidance of many, many other cases too, which is why, I personally appreciate how much time
I don't think it's
both
worth-
parties are taking on this.
I don't think it's worth getting into the Good Government Guide right now, but we can certainly include that. We're going to discuss that in detail at the next.
So I guess, so do we?
Well, okay, so we have some options here. I guess where we're going is an additional continuance. We were planning, I'm not finding it right this sec, but we were planning to meet on December 9th, 2 weeks from yesterday. I don't know if that gives us time to prepare a letter, send that, get a response, all of that.
I'd rather you take a little more time with the holidays and everything,
Okay.
I have no problem.
More like January.
So we're all in favor of holidays.
Even I have no problem with going through till January for you folks. I don't want,
Okay.
I'd rather you do it right and we, not push things.
Okay, so let's make some notes here about who's doing what. I heard that Member David is going to help draft a letter that I'm ultimately going to send to Mr. Lazar and others as appropriate.
I think I would say that we would send it to Mr. Lazar. Mr. Lazar's the city attorney for the Art Commission, who is
Ms. Vera?
Ms. Vera, and the city attorney who advised
Lee.
Ms.
Lee. Okay.
saying we would like clarification on this specific issue.
Right.
That how is, and I think that the issue is very, very specific.
And I think if you could also, sorry to insert this,
No,
but
please.
if you could say also in the letter, I mean, it can't hurt, that you could ask for the attorneys to come to your next meeting.
Right.
Because I think this is a wrinkle that could be smoothed out.
I agree.
And it's just, like I'm talking like a third person, and you need to hear it from the horse's mouth.
Agreed.
And so, and then the other thing I wanted to say is I heartily endorse that the body to hear it be you, be the committee, so that ultimately you could go back to the full task force with a product. This is what's decided on. This is how we resolved it. Yeah.
Very artistically, perhaps.
Yeah.
Yeah, okay. Okay, so I think that's where we're headed. If I could also ask, and I do want to spend, we will take public comment, and I want to spend another moment on the log in a second, but if we could also ask Mr. Lazar to informally check with Ms. Vera and see what impediments, if any, she sees in appearing or participating, and if she says, I won't under any circumstance, if she needs to check with her people, whatever hoops need to be gone through while we're working on the letter, if we need to do something or talk to somebody, if you could let us know so that we can facilitate that, because if we send the letter and the answer is no, you're just stuck with Mr. Lazar, he's the messenger, then we're still at the same place. So,
Let's give it, is it the first Tuesday?
yeah, it'll probably be the first Tuesday in January.
January 7th, so let's throw that.
January 14th.
First Tuesday is 7th.
Oh, I'm sorry, not second Monday.
Yeah, no. First is a Wednesday, which we're not going to have our meeting, so we're going to have 7th, and then we'll have the full task force.
So 6, so then it works to the 13th? Is the 13th a Monday? Yes, so it would be Monday,
Tuesday, right?
no, today we're on a special.
Oh, I see. So
So it'll likely be Monday, January 13th, 3 o'clock. Does that work?
second Monday, right?
Yeah.
Yeah.
Everybody, good, right? Yeah.
Like Monday, not a Tuesday?
Yeah, our normal is Monday, but we do, you never know where you'll find us.
So try and prep Ms. Vera that it'll be the January 13th, 3 o'clock.
Right, so if she's available, you're available, we're all available. Okay. So this is where we're headed. Oh, and Mr. Lazar, if you could, for one more second on the log, I mentioned the consistency about the dates. In some cases where you've got task force complaint numbers, they're in two different places.
Laughs.
Mr. Lazar?
I'm a wasted garbage.
Mr. Lazar?
Yeah, it's like task force case number, if applicable, is that what you're talking about?
Yeah, because in some cases it's in the description, in other cases it's in the case number column.
Well, what that means is that, see, in the description, it's a description of the information or the request
Okay.
that we received. Now, if it results...
Oh, okay.
in
That's
a-
if it results in a case, then it's
Yeah,
there.
and-
If
yeah,
it's in
that's how
reference
that
to a
is.
case, then it's in the description column. Okay.
Right.
There are some other instances, I think they were on the first page, where something stretched over two different lines, and there was some other, I don't know, and this could say, this doesn't have a header on the top, something like San Francisco Arts Commission, Sunshine Log. Anyway, somebody, Ms. Patterson or somebody could pretty it up
She could
a little
pretty
bit.
it up,
Okay.
I mean,
Just so that it's got something. It's got inventory.
It's just used by the Art Commission, it's on the shared drive.
I understand, and it's got inventory list on the bottom left, so I suspect it just came out of some other doc. Anyway, whatever, this document is available for public release anytime the clerks or anybody
Yeah.
else requests it. It can be distributed,
Right.
all of that. And finally, this covers not just the Street Artist Program, but the entire Arts Commission. So it
Correct.
covers the whole department. So ultimately, a document like this could be used as a model for other city departments. And we could say, look, if the Arts Commission can do it, why can't Rec Park or MTA or the Port or anybody? And the fact is they all could, and arguably we should make this a model, and thank you for taking the time to develop it. So, okay, so I think we've got a likely direction. Let's open this up for public comment on item 2. Thanks.
Hello, my name is not Paula Dadish. I changed it legally due to the fact that Howard Lazar cannot run meetings correctly, and I was slandered ad nauseum by somebody called Michael Addario, who I don't know. Lazar let him rant for over an hour, over 3 minutes of public comment.
I'm sorry, we're on item 2?
We are on item 2. I am referring to, there's no page number on this. This is handwritten, I would suppose, in Howard Lazar's hand. This would be page 3, possibly. Page 4. It says 2010-2011, SAP staff. Hours spent on sunshine requests. Hours spent research, draft, reply, copying sunshine task force hearing. So I would assume when he's putting down these hours, he's including who knows what, but I can speak from personal experiences that every immediate disclosure sunshine request that I filed, I did not get the documents requested. The emails that he sent to me were long-winded. They could have been shortened up to 1 or 2 sentences. They did not address the issue. They were circular and off-topic in every single case. So on mine, it was a waste of time. If I make a clear document request, I'm met with a lot of verbiage. Then it goes to Kate Patterson for some reason, who wants to add in her own take on the issue, which is slander, personal attacks. I altered public documents simply because Lazar didn't send the PDF. It just goes on and on. I don't even feed into this nonsense anymore because it's clear that these are handwritten on Lazar's part. Either you're believing his handwrittenness or you're not. And that's the bottom line in all of this logs and accounting and this and that. Yeah, he responded to requests, but they didn't meet the immediate disclosure request on any shape or form. Somebody has to teach him, number 1, how to read, number 2, how to respond to it. They have to have a clearer method for keeping records, which is not copying other members in the Arts Commission, because the list gets bigger and bigger each time, and the original request wasn't answered. I mean, sometimes I get emails with 15 people copied, and it just goes on and on. And that's, in my view, he's probably billing out for this time, when it's just all 1,000% nonsense. I've been at this for a year and never once got a document.
Thank you. Victor, do you have a Post-it note by chance? Just a small Post-it thing?
Stock my bag
Okay.
for future
If we
use.
could just make a note that page 94 and 95 of the Good Government Guide, if we can get those 2 pages put in the file, those appear to me to be related to attorney-client communication and public disclosure 67.24B1(3). So I think that's it, and let's get that in. So if you can just add that. Thanks. Okay. So do we need a motion to continue this to January 13th? Oh, I'm sorry, public, is there any further public comment? Seeing none, public comment is closed. Oh, yeah, I'm sorry, let's have a very brief rebuttal and wrap up. Mr. Lazar first.
Well, I thank you very much, and I'm really pleased that I think we're going to get some conclusion out of this. And I really do hope members of the city attorney's office can be here and weigh in on this, and we can have just a full discussion on that. And I have nothing else to add to that. Yeah.
Great, thank you. And if you need anything further to clarify, we can be in communication on that. Mr. Clark.
Yeah, and I just want to end by saying that I look forward to hopefully somebody from the city attorney's office to be here just to specifically explain why they feel that sunshine request, that the results of those conversations are attorney-client privilege, and so that Mr. Lazar doesn't have to take the heat, because obviously he can't he's only passing on the message. So I'm hoping that you can, convince them that somebody show up here at this meeting and maybe be prepared with some sort of already answer to the questions that we're posing here tonight. So
None of which are new questions, but yes.
Yeah,
right.
same old. And I have no problem with this going forward till January, so we can all have a holiday.
Excellent, thank you. Okay, do we need a motion to continue? Would that be in order? Okay, so I'm looking for a motion.
Motion to continue?
Second. Made by Member David, seconded by Member Highland, to continue this matter to January 13th, 2014, with the letter from this committee, with a copy to the clerks and anyone else who cares, and the directions and pursuant to the discussion we just had. I don't think we need a roll call. Is there any objection to the motion?
None.
No objection. Motion is passed without objection. Thank you all.
Thank you very much.
Very much. If you want to stay for the next item, feel free. If not, we'll see you next time.
I think I'll do my head on now.
All right. Take care. Thank you very much. And if you have anything further to add to the file, please reference the thing, and we're happy to review it. Thank you very much. Very good. Okay. Let's plow on ahead. Can you read item number 3, please?
Item number 3, file number 13005, hearing on the determined violation of complaint filed by Paula Tetesh against the Arts Commission for allegedly failing to respond to an immediate disclosure request for records pertaining to the operations of the Arts Commission.
Okay. Thank you. So we have before us this matter. I'm trying to recall, have we heard this particular item at this committee before, and did we continue it, or did we?
If I can provide a background.
We'll get to that. I'm just trying to figure out where we are procedurally.
This is
I think this is the first time.
It's
Okay.
come before here.
Great. Okay, so Ms. Tetesh, you have 5 minutes. If you can tell us, bring us up to date on where we are and what particular action you'd like of us at this time. Thank you.
Okay, you have before you an immediate disclosure request, which was filed, which has 8 bullet points. It's very clear and very straightforward. I don't see any ambiguity in this. I don't see any room for cryptic notes or whatever. So when it came before the task force, there was allegations that Lazar lost the email but then found it. And Member Neves said, how can you lose an email? And there was no reply. So he was found in violation of record keeping. So since that time, I sent a follow-up email to the task force and to Lazar saying that I haven't gotten any additional documents from you. I went point by point on these 8 issues, and I said the request hasn't been answered, or the request is generic, or the response didn't fill the request, or they haven't responded to the request, which is pretty typical. So I haven't gotten any additional information from him. November 18th, I wrote to the task force saying that I didn't get any additional information. He claims in his response, and this is typical of every response that he responds to, it's peppered with a lot of allegations that I filed 5 in a day. Well, let's see the evidence of the 5 immediate disclosure requests that I filed that day. There are none, so that's just all that verbiage of Howard Lazar. He lost the email, he doesn't have the email, he didn't get the email, or like the one I just filed, oh, his computer broke, or the one he sent to Paula Jessen. I don't remember her email, or maybe it was sent, but maybe I got it back. And Paula Jessen goes out of her way to contact him to kind of help him along with this, which really is self-evident in the first place. So, no, this order or this request was not complied with. I did not get any information. And then going to the sunshine log, yeah, my name appears a lot, but of the immediate disclosures I request, all of them didn't need to be filled in the first place. All he had to do was provide the documentation, but he doesn't do it. He puts in a lot of nonsensical filler. He responded, but it didn't meet any of the things. So I'm referring to his response on March 18th.
Great.
He said it was misplaced and not answered. Well, he said he lost it in front of the task force. A member Niece said, how can you lose an email? And we went one by one. He didn't provide a job description. He didn't provide a breakdown. He didn't provide a job description or a timesheet for Liz Corius, whatever. He clearly misread number 7, and it came along with the snide remarks of Ms. Patterson. I said I went there at 2 o'clock in the afternoon to conduct business. There was no one there. They misread it to 2 a.m. and went on a rant about that. Then we go to, it just goes on and on. The guy even underlines it. And then a technique that he uses very, very often is to resubmit paperwork over and over again, believing that the more he piles up, the more you'll read and believe what he's saying, when in fact he hasn't even answered the original request in the first place. Here on the original immediate disclosure request, I sent it to 3 people, Paula Jessen, Howard Lazar, and clear, straightforward. And what do I get back is a bunch of nonsense from Lazar having nothing to do with anything, and then he'll bill out the hours for it, and he'll claim that he answered the request, which he didn't. And then I have to, I was told by Ms. Osbury not to banter back and forth with him, which I really don't want to. It's time-consuming. No, I'm sorry, you didn't complete the request. But yes, I did. But no, you didn't. This is all nonsense. So you see in my second response on March 19th, one by one, point by point, that he didn't fulfill the request, yet he billed out his hours for it, and that's it.
Great. Thank you. And we'll have questions, and you'll have an opportunity to rebut in a moment. Mr. Lazar, if you can tell us where you are relative...
once
Hold
again...
on. Hold on.
Yes.
If you can tell us where you are relative to the order of determination and any follow-up and anything about policies and procedures, which is the primary purpose of this hearing.
Okay, simply speaking, the order of determination was, that I mailed Ms. Osbury on September 4th, stating that the Arts Commission has already complied with the order, that the Arts Commission previously released the documents long before the August 19th order, in fact, long before the June 5th and July 9th hearings on this matter. The Commission released the documents on March 18th, 2013, as attachments to a letter of the same date to the task force members, and the documents were enumerated and described in the letter. And this material was in compliance with the order. And I find it interesting that Ms. Datish credits me with that March 18th letter when it was clearly written by Kate Patterson. And the documents were attached. The letter went to the task force. It admitted that I was late. Obviously, that was my violation. No contest. But we did subsequently, on March 18th, submit all the documents in reference to every one of these statements. And the fact that she read from that letter to you shows that she received it from the task force clerk's office. So now, you ask, what steps are we taking to try to correct an error of not answering or misplacing requests, the best thing we've done thus far is the logbook, which you dealt with on the previous case, and how the practice is now that when I get a request from someone, before I even do the research on it, I enter it onto the log, the first 3 columns. No, 1, 2, 3, first 4 columns. No, 5, 6 columns. You know, the date, who it's from, what the nature of the request is, you know, and so on. And then I do the research, and then it's fulfilled. Now, sometimes the research involves Kate Patterson or other people. And so after response is sent, then I'm typically the one, if it's a street artist matter, to ask Kate or other people, how much time did you spend in your research? How much time did you spend writing the letter? And I total it all up, and that's what goes in that column of time spent. So that's what we can do. That's the best we can do, and I'm not perfect, never said I was. I'm not going to promise that I'm not going to lose something, okay? But I think this can reduce the opportunity of losing a request. And so I hope that's answered your questions.
Thank you. Okay. Questions, discussion? So let me ask Ms. Ditesh, on the March 18th letter, you did receive that letter from Ms. Patterson with the attachments. We're not going to relitigate the case here, but we did order the Arts Commission should release the requested records in reference to any responsive records to your initial request of February 8th. Were there other items that you believe were not responded to in the March 18th request? You did have a letter to us last week on this matter. Is that your current position?
My position is there are 8 points that are very clear and straightforward, and I responded to each one. The first point, they did not satisfy their request. The second point, they did not satisfy their request. I asked for a job description and timesheets. They provided something else. The fourth point, they did not fulfill the request, but gave some off-topic, generic response. The fifth one...
I understand all that. Let's figure out if there are additional records that are responsive to your request, and if so, Mr. Lazar might make a note and see if he can produce them, because we need, if there is stuff that is responsive to your request, we need to get you, or attempt to help get you that stuff, and that should happen. That should have already happened. If it hasn't happened, let's try to make that happen, and let's see if there's anything further in terms of policies and procedures so that we can dispense with this matter. So,
okay, first off...
if you can be very specific, that would be great.
Okay, first point, I asked for a breakdown of duties. I didn't get an answer to that question.
Okay.
Okay. So if they didn't have the answer, they should have said, we don't have information responsive to that.
Okay.
And that would have satisfied that.
Hold on a second. Let's see how we want to take this. Members, do you want to take these very quickly, one by one, with Mr. Lazar to respond? I mean, I want to get through this because we're going to have to do one way or the other. Fair enough? Okay. So, Victor, do both mics work out there? Can we get you to...
Could I just interject for a minute?
Yeah.
This is not unique to this meeting. disclosure request.
I understand, but that's what we're dealing with.
Every single
I
one
understand. We've heard
did
that.
not need to even be filed in the first place. They're not read correctly.
Okay. I just
They're
want to
not
deal with what's
responded.
before us.
We're focusing on this.
Okay.
We're
Well,
trying to
then
get you your
you're gonna see
stuff.
me- You're going to see me in front of you for the next 50 years.
We should all live that long.
No,
So-
Okay.
So I just want to be clear amongst ourselves that the original finding was that there was not a response in a timely manner to the immediate disclosure.
No, the
request.
original finding was for record keeping.
We're talking here, just hold on a second.
Yeah,
Okay.
yeah. Right, and Ms. Patterson in the letter clearly stated, as Mr. Lazar just stated, that they made a mistake. They misplaced, lost, whatever the word is, right, the email, and that and now they responded to her, now they have responded to I'm sorry, you said your name is no longer Ms. Datesh. How would you like us to
The
refer to you?
artist formerly known as Datesh?
Yes.
I'm almost afraid to give my name.
Fine, that's fine.
I changed it for reasons.
That's fine. So the person formerly known as Ms. Datesh who's here before us, right, the artist formerly known as Ms. Datesh is here before us. So where I'm a little bit confused is we did not, as a task force, say that the responses were insufficient. They said that they failed to respond. They failed to respond within the 5 business days, right?
And that they shall release.
Right, which they did afterwards.
Well, we're not clear on that. They're saying that they released.
Right, but now we're getting into a discussion of whether what they released answered the questions, and that's not. I feel like that is not the purview of this subcommittee.
Yes, thank you.
Okay. Well,
That's my point.
okay.
Yeah.
Point made. Let's see if a little more discussion bears that out. I'm willing. I'm open to hearing a little more. So, Ms. Datesh, if I could ask you to use the other mic, and if we could have Mr. Lazar join you up there, if you're willing to stand side by side for a couple minutes. I'd like to just work through the list and see where we are. So,
I did not bring copies of the voluminous amount of documents with me this time.
that's fine, but you're
Okay.
familiar enough with the
Exactly.
matter. Okay.
Because this letter describes what we gave her.
Understood?
So
Okay.
she says that I'm requesting a breakdown of the duties you, meaning Howard Lazar, perform for the Street Arts program. It says clearly in the letter, attached are Mr. Lazar's job description and timesheets.
Okay.
It's not duties.
Take one at a time. I only.
Okay, could I talk first since I'm...
Yes. Okay.
Wow.
All right. Both of you. Hold on.
I can't take this anymore.
Okay.
Oh, my
We
God.
resolved something on a previous case. I don't feel I deserve this punishment.
No, and we're not.
I have great respect for you people, but to be dragged through this for an hour with this person who's determined to bring me down and not solve anything, I don't feel I deserve this.
I understood, and yeah. Okay.
I really
Let's-
can't
let's-
deal with this.
Hour and a half
Okay.
Clark Brothers hearing.
Okay. Let's all step back for a minute and just everybody relax for a moment. Okay. We need to de-escalate all of this. So let's just do that for a second. Let's take a 2-minute recess. Thanks. Okay, so we are reconvened at 4:48. We were in recess from 4:34 to 4:48, and we're still on item 3.
Mr. Chair.
Yes.
May I offer a
Hold
suggestion?
1 second, Victor.
Am I not on? Oh, great. Okay. Mr. Chair, I wonder if I can make a suggestion that I would like to hear Ms. Datash go through.
Yes.
1 through 8, and, list in each one.
Very briefly.
Very briefly, what her concern is about the response. And then after she...
And what specific
And what
records?
specific, yes.
if
And
any.
then after she's done going through each one through 8, ask Mr. Lazar to come up and respond.
Very
if there's-
briefly.
Very briefly, if there are any additional
Records.
records to her that fulfills Ms. Datash's request.
Rock and roll.
How does that
Yep.
work?
Without objection.
Okay.
We will proceed in that way. Ms. Ditesh, go ahead.
Sounds good, but if I can just...
We have to get your microphone
Your
on.
phone microphone is on.
You're on.
If I can just make a broad overview of a statement that concerns not only this immediate disclosure request, but everyone that I filed. The Mr. Lazar has not taken the time to read the requests. He always seems to brush them aside. In my phone, which I just lost, was a videotape of him where he approached me and I said, Mr. Lazar, did you get my immediate disclosure request?
Ms. Ditesh, if we could really just focus on the specifics of this case, that would be great, because we're running late.
I was so hoping that you were going to educate the Arts Commission or give them some kind of sunshine training, because in 41 years, Lazar has had none. And-
We hear your comments. If you could really focus on the 8 points, that would be great.
Number one, please, Ms. Datash.
Okay,
Thank
number
you.
1, requesting a breakdown of duties that Lazar has responded to. These are duties, not a timesheet or a job description, which is generic, so it didn't satisfy the response. Number 2,
Okay, if that's all they have, then that's all they have, so
well, then they
we'll...
would have said, we don't have records responsive to this, and that
Okay.
would have ended it.
Let's keep going.
Requested breakdown of the duties that Lazar performs for this time period. He did not respond or satisfy that request. He didn't provide the documents. What I got was generic nonsense. Number 3, a breakdown of the duties of Alyssa Licorius for the same time period. It doesn't, I'm asking for the duties. What I got was a generic job description, so it didn't answer the request. Number 4, a breakdown of the duties for the same time period. It's, again, a generic job description, and it's not the duties that this person does. And the reason why I asked it is because the Clark brothers made a complaint that 5% of her time is spent on other duties, so I wanted to see what exactly this person does. I didn't get the information. Number 5, I request any records relating to the timesheets. Well, job descriptions are not job qualifications, so it didn't satisfy the request. If they don't have the information, then they should say, we don't have records responsive to this. I request a verifiable reason for not picking up the phone during business hours and internal emails relating to this within the department. This is a trick that Lazar pulls over and over again. He will move into the third person. It is thought, or we believe, that Ms. Dadish is harassing us. Well, where's the records? Where's the evidence of this? And that's the reason why we're not picking up the phone. I disagree, because they haven't picked up the phone in 30 years. So, they didn't answer the request. And a typical pattern is that Lazar doesn't answer it. It moves to Kay Patterson, who apologizes, but also doesn't answer it. Number 7, I request a reason why no one's been at the front desk. I was there 7 times during business hours to conduct business. I didn't get a response. They misread it and went off on a rant about something that had nothing to do with anything. So that was not fulfilled either. The last one, I sat in a meeting, he walked in, and he told these Board of Craftsmen and examiners, do not engage her. Then I requested a CD audio. I wanted to hear that on the audio, and curiously enough, it wasn't there. That's yet another technique of Lazar, where if I sit at public meetings and speak under public comment, it just doesn't appear under public comment. Subjects of other immediate disclosure requests. Well, the city attorney said, no, it's sunshine law. If you speak under public comment, it must appear under the public record. So that none of these were responded to. At the time, it would have been helpful for me to get this information. So no, the request wasn't fulfilled.
Great, thank you.
Okay.
Mr. Lazar? Your response, and if you can talk for, as to any additional
Well, I think
responsive documents, if there are any.
Okay, if you look through the letter of March 18th that was sent by Kate Patterson, for which Ms. Datish still claims I'm the author, it answers every one of these 8 requests. And it may not answer what she wants, but it answers with what we have. And we even go the distance to explain this is what we have. We do not record a breakdown of the duties that Mr. Lazar performs for the program, nor are the employees of the Arts Commission required under the ordinance to create such a document. We did give her my job description, and that job description, if you saw it, was quite lengthy. And you can see the duties that are involved. That's what a job description does. It's not a general thing. Number 2, breakdown for the duties performed in the other area of San Francisco Arts Commission for that time period. And Ms. Patterson said that I do not perform any duties. Howard Lazar doesn't perform any duties on behalf of the Arts Commission that fall outside of his job description. That's the truth. I have plenty to handle with the Street Artist program. And furthermore, she says that we are not required to log hours spent on each duty. And this document, such a document, does not exist. So she's plainly answering that.
Moving on.
Number 3, I request a breakdown of the duties performed by Alyssa Licouris. And the responses attached are Ms. Licouris's job description and timesheets for the specified dates. Again, a detailed account of the duty and time spent on the task does not exist. Number 4, I request a breakdown of duties performed by Licouris on duties spent for this commission for the same time period. Ms. Licouris' job description is attached. Because she is stationed near the front door of the Arts Commission's office, she occasionally performs receptionist duties, such as alerting other staff members when their guests have arrived. That's what we've always done at the Art Commission. We've been a small department. That's what we've done since 1972, since I've been there. We all help out each other.
Artfully.
Yes, artfully. Hopefully artfully. We are providing all timesheets. And then she says, number 5, I request any and all records relating to timesheets of both employees for the time period. Job description as filled with DHR and job qualifications. Okay, the response is we're providing all timesheets for both employees and their official job descriptions. And then it goes on to explain that the Department of Human Resources has the same job descriptions on file. However, they're in a slightly different format, but the verbiage is identical to those provided to Ms. Datish. Number 6, I request a verifiable reason for no one picking up both phone during business hours and any and all records relating to this, inclusive our internal emails within the department. And see, Ms. Patterson's response was, the Street Arts program's official business hours are 9 a.m. to noon and 1 to 4 p.m. During this time, both Mr. Lazar and Ms. Licouris regularly answer phone calls. However, in recent months, Mr. Lazar and Ms. Licoris have stopped answering calls they believe to be from Ms. Datish because of their harassing nature. Attached, you will find an email exchange between Mr. Lazar and the agency's director, that's Tom DeCaney, about Ms. Datish's ongoing harassment, in which Director DeCaney instructs Mr. Lazar not to pick up the phone. Number 7, she's requesting a verifiable reason why no one has been at the front desk during business hours the past 7 times. I went there to conduct business. I request a verifiable reason as to why no one was there at 2 a.m. That's what she said, a.m. We didn't say a.m., she said a.m. And so the response from Ms. Patterson was, without knowing exactly what time Ms. Datish visited the Arts Commission, we can't refute her claim that nobody was at the front desk. However, we can say definitely no staff member is in the office at 2 a.m. I don't want to read the whole thing to you.
That's fine. And if you had anything on item 8, and then we're
Item
done?
8 was, she was requesting, she said that she requested records relating to a statement that I made at the beginning of a public meeting of the Board of Craftsmen Examiners. That's the Advisory Committee of Street Arts and Crafts Examiners in February 2000. And she says that my statement was, don't engage her, meaning Datish, which did not appear in the CD audio that was sent to her. And that she was requesting records relevant to that, inclusive of our internal emails within the department. And so the February meeting took place actually on Thursday, February 28th, and that this email predates the February meeting. Her email predated our February meeting.
Okay, so
Therefore, we believe the meeting in question took place on January 31st. That's what she probably meant. And then it says, please find the minutes attached for this meeting attached. We have no internal emails related to this incident. And if it didn't appear on an audio recording, perhaps it was said before the meeting started, and we're not required to have the audio recording going before the meeting starts.
got it. Okay, so to summarize, you referenced the the March 18th, 2013 letter, and are you telling us now that you have no additional responsive records to her inquiry, and you have made, albeit late, the response, and you have nothing further to offer?
Absolutely. We have nothing further.
Okay.
Yeah.
So that's as to records, that's cool. And as to the Commission's policies and processes for responding to public records requests, you talked earlier at length about the log and the
Correct.
procedures that you have. The log, I think, is pretty self-explanatory. We might do something in the future to give a paragraph description of what the log is, what it includes, how employees are instructed to add things and to maintain it, and that it's available as a public record, so just as a guide to the log, but it is certainly something that everyone in your office knows about, uses, references.
Right.
It's no state secret.
Right.
And you have worked to develop that and to train others so that people know that that is the procedure, so things may still get lost, but that is not the idea, and more things should be captured, logged, regardless of who they get sent to, when they get sent, how they arrive, so everything does get processed, and as much as possible, things are responded to on a timely basis.
Right.
Yes? All of the above?
Yes.
Okay.
Yeah, log's a big help for us.
Great, thank you. Any further discussion or questions from members?
If I could add something.
You'll have an opportunity in a moment. We're good? Member Highland? It's good? Okay, so is there any speakers in support? No. Is there any public comment? No. Let's have a chance for rebuttal and wrap-up. Mr. Lazar, do you have anything further to add?
No, sir, I do not.
Thank you. And Ms. Ditesh, you get the last word on this?
Okay, I'm referring to the original email of February 7, 2013, and all someone has to do is read it. It's real clear and very simple. So it wasn't 2 a.m., it was 2 p.m. It just goes on and on. He likes to get his foot in the door by making claims of events that haven't happened to throw you off when, in fact, I've asked clear and specific questions. Why wasn't somebody there the 7 times I was there? I don't know. I wasn't there. Maybe we could put a camera, maybe this, maybe that. No, nothing like that. Patterson wasn't there. She doesn't know. She didn't see it. I mean, it just goes on and on. And if I could just simply say, but what you've observed here today is an enormous amount of hostility on the part of Lazar, and that extends out to the street as well, because I've been in and out of that program for a long time, and he's done the same to me. He'll come out on the street under the guise of an inspection, and he'll rant to me about how the Clark brothers have spent so much of your money on sunshine requests, and that creates a lot of hostility within the program. And not only are the record requests not satisfied, you have YouTube videos that post on the internet of a market manager slandering the Clark brothers, and the Clark brothers telling me about it. I don't know any one of them, and it all has to do with record requests. And that's why I've completely removed myself from this. If you just look at the original email of February 7th, any reasonable person would read through it and they'd say, we don't have records responsive to this. One sentence is all it takes. We don't know, but we'll look into it. 1 or 2 sentences would have satisfied this. In every request, Lazar was late, the computer was broken, he didn't get the email. I mean, it just goes on. And it's not limited to this. It was the same at the appeals board, which was on TV. So I was hoping that the purpose of my coming today was education and outreach, for somebody to sit down with these people to explain to them, this is how you write the minutes. You don't include somebody's statement 5 separate times. You don't omit public comment when somebody was there. You don't misinterpret what somebody said completely. You don't put somebody's email in but leave somebody's out. These are rules, and we're going to educate you and explain to you how to do this. That's it.
Thank you. Okay, so to summarize and hopefully conclude this matter, you requested records. The department admitted that they didn't provide them on a timely basis, but they did disclose records responsive to your series of inquiries and questions. All 3 of the members present supported the order of determination and finding of violation. We have now held a follow-up hearing, discussed each of your requests and the department's response, and discussed the adequacy of the Commission's policies and processes for responding to public records requests. So unless there is further discussion or action or a motion or anything, I'm going to deem this matter concluded with no further action to be taken.
Thank you.
Okay. Thank you. I think we're good on item 3. You're welcome to stay for item 4 or be on your merry way, Mr. Lazar. We will see you in the next year unless we see you beforehand. Happy holidays.
Happy Thanksgiving.
Yes. Thanksgivica this year.
Thanksgiving, that's
yes, very good.
Chair Pilpel,
Yes.
I need to ask that item 4 be, what's the word I'm looking for?
We're going to continue it. If I can just have like 2 minutes on it.
Okay.
You got to go?
I have childcare issues.
Okay.
So, yes.
If I can just run through it very quick, and then we will continue that. So that's fine. If we can just call it very quickly.
Item number 4, discussion, public access to records and meetings of nonprofit organizations.
Great. So based on the Charles Pitt's complaint and some of my concerns about timeliness and interpretation, I gave you a copy of the 2 handouts. Victor, you've got one for the file. Member Highland. I was able to get from HSA their grievance procedures, and I started to draft a lengthy letter of inquiry. I've not completed this, so that's why it's got draft, and I got to figure out how to put the draft behind rather than in front. But I'd like to complete this at our next meeting and send it out for department comment. My big concern, quite frankly, is trying to figure out when an entity becomes subject to 12L and when they become no longer subject to it because the financial activity level has dropped. And it might seem easy, but further analysis suggests that it's complicated. So that's where we... Was this yours? Yes. Take it. Go ahead. Okay, so feel free to read those. We will chat about them further at the next meeting. Any discussion on that? Seeing none, is there any public comment? Seeing none, we will continue that to the next meeting. We don't need a motion. We'll do that without objection. Okay. That's item 4. Item 5, I'll just do this public comment. Members of the public, is there any public comment? Seeing none. Item 6, announcements, etc. For our next meeting, which is scheduled for Monday, December 9th at 3 o'clock. We've got the continuation of the 12L discussion. We will discuss the Sunshine Ordinance Task Force website. I'm trying to get staff. We may or may not get staff, but if members have concerns about what's on the website, how it's categorized, PDF versus docs, old stuff, new stuff, whatever your thoughts about the website, and either way, Victor will find some way to display the website on the screen. We'll find a way. Is there anything else that members want for December 9th? I may cook up some other stuff.
What about that letter we're supposed to write to Camilo?
Okay. That is still in the works. Let me see if I need to schedule that or if I can get it out before. Ray Hart's, yes. That would be a nice holiday present. Okay. Anything else? Okay. I'm working towards stuff. We're trying to get that stuff dealt with, and so we can get on to some positive things. So that's stuff that's upcoming for December 9th and in the future. Any public comment on item 6? Seeing none. Is there any further business before the body?
Completes the agenda.
Excellent. We are adjourned at 5:10. Thank you.
Thank you. Have a good Thanksgiving. Sorry. Have a good Thanksgiving.